Hello, welcome to Workplace Wake Up. I'm Jen Shaw. Every week, I spend about 15 minutes covering key legal developments, introducing you to interesting guests, and providing some entertainment to start your workday. I hope you enjoyed this week's episode. So today, we're going to talk about a new California law that we haven't really addressed that covers reproductive loss leave. And the reason that I want to talk about this is it has come up for a number of clients recently. So sometimes when these new laws pass in California, they don't really come up too much, but we have had a number of questions about this law. So it's actually really interesting. So what do I want you to know? Okay, SB 848 is the law that we're talking about. It expanded bereavement leave and allows employees to take up to 5 days of protected leave following what they call a reproductive loss event. It also protects employees from termination, discrimination, and retaliation if they exercise those rights. Now, this law was effective on January 1, 2024. So for all of you who have not updated your employee handbooks, you need to do that to make sure that you understand what your obligations are and your employees know what you're supposed to be doing and what they can ask for. So the obvious first question for everybody is, what is a reproductive loss event? Well, it's defined by the new law to include a failed adoption or surrogacy, miscarriage, a stillbirth, or unsuccessful assisted reproduction, or IVF. Now, what's interesting is it applies to any person who would have been a parent as a result of whatever the unsuccessful event was. So whether that's adoption, surrogacy, assisted reproduction, or pregnancy. Okay, so very broadly defined. Now, it is unpaid, just like bereavement leave. Okay, so you don't get paid for reproductive loss leave unless you decide to have an internal policy where you allow that to be the case. However, you must allow employees who use reproductive loss leave to take their accrued vacation, PTO, sick time, whatever may be available. If you're a public sector employer, you may even have comp time that's available. Remember, most private sector employers can't offer comp time. It's illegal. But if you're a public sector employer, there may be also some options there that folks could use comp time. Now, do you have to keep this confidential? Because obviously this is, some of these items are, of course, very personal. In fact, I would argue probably all of them are. So do you have to keep the information confidential? Yes, you do. But employees do have to request the leave. You don't have to read their minds on this. And they do have to provide information or documentation to allow you to evaluate whether they are entitled to reproductive loss leave. Just like with any HR related issue, we think it's really important to only share this information on a need to know basis, not on a want to know basis, but on a need to know basis. Who needs to know what's going on? Now, what about regular documentation, right? So the employee does not have to give you any specific documentation, but they do have to request the leave. But they don't have to give you evidence that the leave is necessary. That is unlike, for example, bereavement leave, which requires employees to provide that documentation. So in many ways, this is like California Healthy Workplace, Healthy Families Act sick leave, right? Where you can't ask for the documentation unless you have a reason to do so. So a legitimate concern about the validity of the leave, for example. Now, there are some restrictions and limitations on this law. For example, it only applies to employees who have worked with you for at least 30 days. But there's no limitation on how many times they can take this leave during the year in terms of the number of times. Now, the total amount of days is 20 days within a 12-month period. How did they come up with 20 days? I have no idea. I don't know. That's just what they came up with. And the leave does not have to be taken consecutively. So you might have a doctor's appointment here and a doctor's appointment there, but it does have to be completed. The 20 days have to be completed within 3 months of the reproductive loss event. All right. So I always joke about California that there are so many rules. There's so many ways for employees to be off work that we almost need a law that tells them, by the way, you're supposed to come to work, right? It's very frustrating for employers, and I get that. This is yet another type of leave that, as I said earlier, must be reflected in your employee handbook or whatever documentation you're giving to your employees. Now, just like with other leaves of absence, you need to review your policies and procedures to make sure that you are on top of this law, that there's nothing in the law that is contradictory to your policies or procedures. It's going to be important for you to figure out how you want to handle reproductive loss leave. Do you want to make it paid time where the company or the organization pays for it? If you don't do that, remember you have to let them use any accrued time, whether that's sick leave or PTO or vacation. You want to make sure that you have a point of contact. So just like when we talk about other leave issues, someone needs to own this process, just like we spoke a while ago about the process that folks need to have in organizations for wage hour compliance, and somebody needs to own that process. You need somebody who's going to be responsible to ensure that that process is being followed. You also need to make sure you give your employees notice of their entitlement to this right, and that you educate managers and supervisors not to deny leave, especially for some of these more obscure provisions. For example, the way they define a reproductive loss event as being unsuccessful assisted reproduction. So if somebody's IVF cycle fails and they come to you and say, I'm really upset and I need to take some time off, you might be tempted to say, well, gosh, I'm sorry, but that doesn't seem like it's covered under the FMLA or the CFRA, and we're really busy, blah, blah, blah. Okay, that's all fine. Give them the time. It's unpaid time. It also cannot be counted against them in terms of your attendance policies. This is protected leave. So just like with all of the other protections we have, you want to make sure that you remember that employees are protected from termination, discrimination, and retaliation for enforcing any of these laws. Now, one of the things that people have talked about is how this law would sort of dovetail with the bereavement leave, because it is within bereavement leave, but it is a separate entitlement. So unlike, for example, the CFRA, where you have a number of different situations for which individuals may use the California Family Rights Act, this is actually just an additional part of bereavement leave, but it is separate. So these 20 days of reproductive leave are not going to run concurrently with that bereavement leave that you had to address in your policies a couple of years back. So what you want to remember when you're talking about reproductive loss leave is that there may be some folks with strong feelings about the types of things that are protected. And when you look at the sort of culture, I guess, right now, what's going on, the environment in terms of overturning Roe versus Wade, and people have very strong views about that on both sides. And then we've got this whole issue with the Pregnant Workers Fairness Act, which I talked to you about a couple of weeks ago, which actually protects abortions and gives employees the right to take time off. There's a lot going on here in this area. I think the most important thing for you to do is something we already talked about. You've got to have somebody in the organization who is prepared to handle these issues. And one of the things that we find with leaves of absence and reasonable accommodation, just like wage hour, you need to stay on top of the developments. This is why we have our yearly 2-day workshop for individuals, either for newer HR folks or more seasoned veterans who need information about managing leaves and reasonable accommodations, because they are tricky and they are not so obvious sometimes in terms of how you should handle them. So you need somebody internally who is educated, who is up to date, who can help you figure this out. If you want to use a vendor, you can use a vendor. Just make sure that, as we've talked about in the past, they're aware of the California requirements and they're prepared to comply with them. The last thing you need is somebody who will not do that. Just because somebody offers a great price from Pennsylvania doesn't mean that you should use their documents if you're in California. You have to be really, really careful about that. The other thing about reproductive loss leave, I guess, that I want to leave you with is that it's not going to be the end. There are already a number of pending proposals in the legislature to provide other bases for employees to take time off. So at least in California and in other states as well, we continue to expand the right of employees to take time off for any number of things. And the more we get into this area of reproductive loss, where we're talking about the voluntary cessation of a pregnancy or failed IVF, there's a lot that's going on here. And there are going to be a lot of emotions by the employee. There are going to be a lot of people feeling a certain way. You've got to make sure that you're really empathetic, regardless of your own views in this area. That's not always easy for me, but it's critical for you to be empathetic and really understand what the employee is asking you and why they're asking you and what you can provide to them. Because here's the problem. There are so many leave laws now that you're bound to get hit by something. You're bound to have a lawyer at one point say, well, you know what? I don't think they did that right, or I don't think they did this right. And then they throw the kitchen sink at you. They put everything they can possibly think of that you might not have complied with in that civil complaint. And then they want you to negotiate to settle it, because that's always the goal of litigation. They want to get sent to mediation and get a check written to them. Okay. They don't really want to go to trial. That's not in the cards. Now, some employers are very dedicated to that concept, so they'll go to trial. So that means in those situations, the individual manager or supervisor may not be so eager to resolve the situation. But work with HR, figure out what HR wants you to do, and then make sure you're ready to go in terms of the steps you need to take to be sure you're in compliance. With these new laws, there aren't a lot of random check-ins. The folks who enforce them are not just going to come by and see if you're doing okay. This is going to come up when somebody's terminated and maybe they've taken too much time off after losing a child, whatever it may be. We know the California Family Rights Act doesn't cover them for the loss of the child, but it certainly could give them some time under pregnancy disability and the California Family Rights Act to deal with the loss of the child. What this law does, though, is make it much more clear. It just makes it much more clear what the employer should be doing and how it should be done. So put this on your list of things to do. I won't always give you a list of things to do during these podcasts, but many times I will, because I only have 15 minutes and I want you to avoid liability. I don't want you to end up in a situation where you're writing a check to someone because you didn't know that there was a rule out there. It's very, very difficult to stay on top of these things. I know that. Be sure you join us for the podcast. Watch for our blogs. They come out every Monday, so you can look at the blog. We also do regular training sessions. Don't forget, we've got our criminal history webinar on the 27th. We've got the Pregnant Workers Fairness Act on June 4th. That was June 27th, by the way. And then we're doing also a webinar on separation agreements, confidentiality agreements, trade secret agreements, etc., and the risks that are inherent in requiring employees to sign those agreements. They're often necessary, but they have to be written correctly. That webinar is on May 23rd. So all you have to do is go to our website, check out the webinars. Let me know if you have any suggestions, any ideas about how we can improve the podcast, or guests you'd like us to interview, or things you'd like us to cover. It is always my honor and privilege to join you for this time. Thank you so much for taking the time to join me, and I'll see you next time. Workplace Wake Up, including our guests and hosts, do not provide legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction. If you enjoyed this episode and would like to spread the word, please share it with others, post about it on social media, and/or rate and review it. You can also follow us on LinkedIn, Twitter, and Facebook, and email us at info@shawlawgroup.com.